Now, the court will proceed with the findings made in this matter. And as stated, the findings are based on the rules pertaining to circumstantial evidence, keeping in mind the two cardinal rules already placed on record, but which the court will repeat at a later stage. Firstly, the inference, or it can be said, that all the relevant persons as per the evidence of this entire case were in East London, that the firearm booked to Mr. Mavundla was, according to him, not in his personal possession, but no explanation has been given as to where it was kept in Gauteng. The registers of the KZN unit indeed states it was booked out to Gauteng Larry Mavundla. But where was it kept since 28 July or since his departure in Gauteng? Mavundla, through Advocate Matthews, informed him that the breech block was not changed or altered. And now, if he left the SP249 in Gauteng and came to East London, it was not in his personal control as stated. However, the question is seen as a mere question put during cross-exam and remains just that, a statement in cross-exam. Therefore, the person who informed Advocate Matthews of this fact then should have been called, and he is in no position to give such information since it is his version of the defense that the firearm was in Gauteng. Now, as to what happened and where it was kept, no explanation was provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equates to? That specific firearm is booked out to him for whenever it is needed for him or by him, since clearly it does not mean it needs to be on his body since he left it in Gauteng. Further, on considering those aspects, why would the two firearms in question be called in and said please take this for ballistic testing? However, the others that were booked out in the register was not brought in on the day Colonel Janssen left on the 6th. Just the two in question. Further, the court is obliged to look at that the said cartridge was found, as the evidence was accepted of Colonel Ngwadleka. It was matched with SPA 249-14, and the conclusions on the record by Ngwadleka have already been placed on record. And since I'm pressed for time, also further, accused one says he is the only person who fired an object resembling a firearm, no one else. The grounds were inspected the morning of the event, and no cartridges were found, and the area was declared safe. Therefore, the two cardinal rules for the court to draw inferences on the evidence presented, and which I have now stated on record as a reasoning, as to the reasons why the court has arrived at its decision. I remind you the cardinal rules being, firstly, that the inference sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such that they exclude every reasonable inference from them save the one sought. In this instance, the question or the pertinent question then remains whether the court can infer, based on the reasons placed on record, including the evidence that it had dealt with over the last 2 days, whether such inference can be made. And the court finds as follows. Indeed, the inference sought is supported by all the facts contained as per the evidence presented in court, and therefore the following findings are made. You may stand up, accused 1 and 2. Accused 1, in respect of counts 1, 2, 3, 4, and 5, you are found guilty as charged. Accused 2, Mr. Snyman, in respect of counts 4 and 6, you are found not guilty and discharged. You may be seated. Okay. At this point, the court will then just... Is there something you wanted to place on record?
Yes, Your Worship, I just want to say accused number 1 is no previous conviction.
Same is noted.
At this stage, because of the shortage of time, my instructions are to apply for postponement and for the continued release of the accused on what he's been on what since the outset and has always appeared in court.
The court has no intention of changing the status of your client, Advocate Ode, so I'm completely in agreement with that, and further that it's not possible to deal with the rest of the proceedings today.
In that regard, Your Worship, I intend to obtain a pre-sentence report, and for that purpose, we need to arrange a date with Your Worship.
Okay, so at this point, just so that you may have a word with your client regarding his schedule, of course, Advocate Matthews, you are now excused from record.
I'm going to catch my train.
Yes, it